Fire Away tackles burning questions and hot topics in Canadian employment law, human resources, and dispute resolution. Hosted by Rudner Law, Fire Away is your go-to source for legal insight on the world of work. So whether you are an employee or an employer, a lawyer or an HR pro, let's ignite the conversation and get into today's episode. Here's your host, employment lawyer and partner at Rudner Law, Brittany Taylor.
Hello, and welcome to Season 7, Episode 5 of Fire Away. Today, we welcome Jacqueline Bart back to the show. Jacqueline is a Law Society certified immigration specialist with over 30 years of experience in Canadian immigration law. She is the managing partner of the award-winning, nationally and internationally ranked Bart Law LLP. Bart Law specializes in employer non-compliance defense. So we're going to get into today what employers need to know about compliance requirements related to immigration. So let's jump right in. Welcome back to the show, Jacqueline. It's such a pleasure to have you back.
Oh, it's such a pleasure to be here. Thank you so much, Brittany.
No, absolutely. So as a preliminary question, just to kind of ease us into our discussion today about compliance, let's talk about who this is going to apply to. So what kind of employers are going to have additional compliance requirements from an immigration law perspective?
Yeah, so the kinds of employers that would require attention to compliance from an immigration law perspective would be employers who hire foreign nationals or who sponsor foreign workers. It also would apply to employers who hire contractors who are de facto employees, which happens often when employers are trying to bypass immigration requirements. And we all know that's a no-no from an employment standpoint, from a tax standpoint. It's also a no-no from an immigration standpoint. So people need to be very careful when they're employing individuals not to finesse the situation too much. They need to focus on compliance because, and just to go back to the original provisions in the Act that require compliance, the wording of the Act specifically states, and this is the Immigration Act, Section 124, every person commits an offense who employs a foreign national in a capacity in which the foreign national is not authorized by this Act to be employed. And that particular provision catapults all the legislation regarding compliance that's in the immigration regulations and the appendixes and annexes to the regulations. So there's always compliance requirements when hiring a foreign national, and compliance can vary considerably depending on the work permit or the work permit exemption. So there's even compliance requirements regarding visitors entering to work at your company, because sometimes they won't need a work permit, they're work permit exempt. So it's really important to understand the different types of compliance. So just before we talk about that, I think it's important to talk about the purpose of compliance requirements, because people are wondering, why are employers regulated yet one more time? We pay all these different levels of tax. We've got all these employment requirements. We've just got all these crazy corporate requirements, and now we've got immigration compliance, because it's almost impossible to avoid not hiring foreign workers. So the purpose of compliance, and this is really important so that you understand how the legislation works better, is to ensure that the foreign national is treated like a Canadian, basically to eliminate exploitation, to eliminate illegal immigration, and to provide employment opportunities to Canadian workers and permanent residents that are equivalent to those that are provided to the foreign national. So basically, the government doesn't want the foreign national being exploited, but they don't want people being hired over and above Canadians. So the legislation is designed to eliminate exploitation, and it's designed to give Canadian workers a leg up. So we're only bringing in foreign workers when it's absolutely necessary. And then I can go on and explain the 4 compliance tiers, unless you have any questions at this point, Brittany.
No, I mean, that's really, really helpful so far. And I think I just want to note something that you kind of highlighted is the fact that there is this kind of overarching responsibility on employers to make sure that the people that they are hiring to work for them are legally able to work here in Canada. And I
Exactly.
think this is like a big question that I get all the
Yeah.
time, because we always put as a condition when we're drafting an employment agreement for an employer that they
Mm.
have to make sure the person is legally eligible to work in Canada. And I think one of the questions that we sometimes get back is, why is this my responsibility? Right?
Mhm.
Why am I what do I have to
Yeah,
do to verify that this person is
exactly.
legally eligible to
Yeah.
work in Canada? So I'm grateful for you for answering that question before I even asked it. Of this is why, this is where this comes from,
Yeah.
is this overarching kind of obligation.
Yes, it is. That's exactly it. Yeah. And in terms of ensuring that an employee has the right status, the employer they do have to exercise due diligence, and they have to prove that they tried to exercise due diligence so that they did everything they could in order to make sure that the employee was legal. And obviously mistakes can happen, or the employer is deceived and there's documentation that either is fraudulent or incorrect. So all of that needs to be part of the document retention that an employer does when they're hiring foreign nationals. And in terms of compliance, I'm going to talk about the 4 compliance tiers in terms of levels of work authorizations. And when I say work authorizations, I'm talking about both employment authorizations as well as visitor work authorizations. So work permits, including labor market impact assessment requiring or based work permits, as well as regular work permits where the employer is still sponsoring the employee, but it's an exemption to the labor market impact assessment process. So the 4 compliance tiers in terms of level of difficulty for compliance for employers to level of less difficulty and really minor compliance for employers are as follows. The first one is the labor market impact assessment compliance, because not only do you have the regular Immigration Act compliance, but you also have the labor market obligations that employers have in terms of the transition plan, the employer commitments that they make when they agree to a labor market. And within that rubric of the labor market impact assessment um, process, under the foreign worker program, you also have a lot of different types of labor market impact assessments. So you've got Schedule A, you've got Schedule B, you've got agriculture, you've got low skilled, you've got high skilled, you've got uh, advertising exempt workers. So again, there's a variation in terms of compliance requirements. And actually in our office, what we do is whenever someone applies for a work permit or applies for a work permit exempt authorization, we will send the employer exactly what they need to do in terms of compliance. So we list it, bang, 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 bang. This is what you need to do. And then it's easy for the employer, and they just diarize the dates. And if they want, we can also diarize the dates as well. But that knowledge of what you need to do is often absent when you as an employer, when you prepare the work permit documentation. The employee gets the work permit. You're like, woo! He got his work permit. He can start tomorrow. Thank
My
goodness.
job here is done.
My job here is done. Well, no, I'm sorry, but your job is not done. So the second one that I wanted to talk about is the IMP, the Immigration Mobility Program, which is basically all the exemption to the labor market impact assessment. So those are work permit LMIA exempt compliance requirements, and a work permit is still required under the IMP. Basically, compliance documentation is filed into the employer portal, and then based on that, the compliance requirements would apply. And again, there's certain requirements under this program. They're not as onerous as under the labor market impact assessment program, but both these, the LMIA and the IMP, are both employer-sponsored applications. So they tend to be more compliance heavy than the work permit exempt workers. And the third one is work permit exempt workers, meaning that they're authorized to work in Canada, either say as after sales workers, where you need to demonstrate that they've got specialized knowledge and that there's a agreement for the sale or lease of equipment manufactured outside of Canada. And these after sales service workers are coming in to basically install or supervise or commission or do something with the equipment, and they can have their hands on the equipment. They can modify the equipment, they can customize it, same with technology. So when they get that special after sales service worker documentation, it's actually a visitor visa, but the employer in Canada, even if they're not employing them per se, as long as they're at their work site, they need to verify that this person has the right status for Canada. So, and that their work permit exempt status is not expiring before they finish the work. Otherwise, they will need a renewal.
Right.
So, and then the last category is basically the open work permit status that certain people have. For example, Iranians, Israelis, Palestinians, other individuals from various other countries, including refugee applicants, have open work permits. There's minor compliance with those particular work permits as well. And the most important thing, obviously, is that they don't expire, because if they expire, then the worker is working out of status and the company is liable. There are other requirements as well, and we'll get into those a bit later, but those are the basic 4 options in terms of compliance and levels of difficulty maintaining employer compliance.
That's really helpful and really interesting. I think a lot of the times that we're just thinking about kind of work permit, permanent resident, Canadian citizen as kind of the category. So it's really helpful to kind of unpack that and recognize that there are different levels that we're talking about. And I think the other thing that is very comforting from all the information that you just provided is that in every single one of these tiers, there is some documentation that the employer either already has, right, because they're actively participating in preparing the work permit documents, or some type of certificate or some type of documentation that's going to give the employer that comfort of knowing I've done my due diligence and I understand the terms upon which this person is legally eligible to work in Canada. But as you pointed out, this is not something that you can just do as a set it and forget it exercise, because there are these, in some cases, ongoing compliance requirements. And there's also expiration dates, right? If somebody has a work permit and then that work permit expires, they are no longer legally eligible to work in Canada at that point in time. So that's really all very, very interesting, and I think really helpful for employers. In terms of, we've talked a lot about compliance and the compliance requirements. So who is checking in on this, and what does that look like when there's kind of a checkup to see if an employer is engaging in the compliance activities that they need to be doing?
Yeah. So basically, the purpose of the government reviews, the compliance requirements, is so that that employers remain accountable to the requirements of the Foreign Worker Program or the IMP. And so they need to meet all the conditions and requirements of either the Temporary Foreign Worker Program or the IMP. With the labor market impact assessment, as I mentioned earlier, the requirements of the employer are set out not only in the decision letter with the annexes, but also in terms of the commitments that the employer actually signs and negotiates with Immigration Canada. When we're dealing with agricultural workers, the compliance requirements are a little bit different, for example, or low-skilled workers, where you have to provide housing and the housing is inspected regularly, or with just low-skilled workers generally, including agricultural workers, you need to pay the ticket and send them back to their home country. Same with personal support workers, for example. So those are requirements. Sometimes foreign workers are hired and there's a union involved. And generally compliance by the union is required. It hasn't been required in the recent past, and that's created some issues. So the government is looking at union concurrence more and more, and they're going to legislate this fairly soon in the future. I anticipate within the next 6 months or so. But sometimes once the foreign worker comes to Canada, there's disputes between the management and the union, and one of the disputes might revolve around foreign worker treatment. So there may be an agreement, say, to cut down hours if there's not as much work, and if hours are cut from the foreign workers, it means they're no longer in compliance with their commitment. So that creates an issue. And then, say, for example, the union might start a grievance about the fact that foreign workers are treated better than Canadians, and that's an issue. So you can run into all sorts of issues of compliance. And obviously the most straightforward way to eliminate this non-compliance is to terminate the foreign workers and send them back. And I know that we're going to be talking about termination later, and it relates to immigration obligations. But I'm just giving you an example of the kind of compliance issues that could arise. And people don't think about that from a compliance perspective, but the kinds of information that is reviewed on a compliance review are wage. So basically, if you're making a commitment to an employer in terms of wage, you have to keep that commitment. If you go higher, you could be in trouble if it's substantially higher, because basically you advertised a certain position, and if you had been paying much more, then perhaps Canadians could have taken advantage of that higher salary. So it's these kinds of issues that arise that create the kinds of compliance review problems that people don't really sometimes anticipate. The job title is an issue, the job duties, the benefits, the vacation. If you make a promise to give someone 4 weeks vacation and then they don't take it, it's a real issue with foreign workers. Not so much with Canadians, but with foreign workers, you're basically exploiting them if they don't take the vacation that they were promised. So that can be a real issue, and it's a real issue with CEOs, because CEOs may not want to be forced to take a vacation, or the company makes a commitment, but the CEO is really in charge of their own salary at some particular institutions, or they may vary their holidays and take way more or way less. So we have a lot of compliance issues with foreign worker CEOs. So vacation, location of work. So if the employer changes location, that's an issue. If the employer is not engaged in the business, if their presence in Canada is not happening, and they're supposed to be in Canada, that can be an issue. Provision of information regarding workers' rights. You have to inform the worker of your rights. If you don't inform the workers and employer of your rights, it's an issue. In the past, what we would do, just so that the employer was always compliant, was we would send a letter to the employee with all their foreign worker requirements when they came to Canada with the SIN and all the requirements that they need in order to work in Canada, driver's license, customs, etc. And we would also include a link to the website that requires that is required by the legislation for the employers to provide information about human rights to the employee. But now the government is saying, no, in addition to that, you have to post it, and the employee needs to be aware of it regularly. And we brought an HR manager to Canada, foreign worker, who very senior VP of a company, and we hadn't posted the requirements the way that government recently, and this was after we provided the information, and it was very recently before the compliance that the government said, no, we generally you should post. So we had to provide a justification and a defense explaining this is what this guy does. He understands human rights. He's aware of it. He's enforcing all the human rights for Canadians. So that's why it's not necessary to advise them on a yearly basis. and the law doesn't require that you advise the foreign worker on a yearly basis. It's recommended, but not necessarily yearly. It's periodically. But sometimes the compliance review can be a little bit niggly when really it's not necessary. There's a huge difference between a VP of HR and agricultural worker in terms of understanding of their rights. So, and the government looks at compliance in federal and provincial laws, compliance with requests from inspectors, attendance at inspections, a workplace free of abuse, anti-harassment for foreign workers, and the important thing is to retain the documentation confirming compliance, because if you don't have documentation and you're scratching your head when the inspection occurs, then you're in trouble already. It's a bad sign already, and that's a real issue because document retention is required for 6 years, sort of like under the Income Tax Act. You need to keep the signed agreement. Workers' compensation also is looked at. So there's a number of things, and obviously all of these vary depending on the compliance requirements for the particular tier of compliance that we discussed earlier.
Yeah, absolutely. That's really interesting. And it's funny how there is some similarity when in terms of the advice that you're providing. For example, when we're talking to employers about their compliance with, for example, the Employment Standards Act, we say a lot of the same things, right? If you don't have records, if you don't have documentation, how are you going to prove that you're making sure that everybody's received their overtime pay or that everybody's taken their vacation time, to your point, which is definitely a problem that strangely emerges of people not taking vacation time. But so it's a lot of the same advice. I think what's interesting that I picked up on one of the things that you were saying is that we would tend to think about compliance, making sure, like you were saying, that foreign workers are not being exploited. But there's also this concern that you're kind of rigid to the promises that you've made, even if what you're suggesting is a benefit, right? So even if we're talking about increasing the compensation or promoting the individual, there's still a concern here because you've made a promise, you've made a commitment.
Yeah. Yeah.
And you could be bound to that. And so that's so interesting because that's not something that we would typically be concerned about in a situation where we were employing like a Canadian citizen and we're talking about promotion or giving them a raise. That would not be something that we would typically be concerned about. We would see it as an opportunity to perhaps have them sign an updated employment agreement. But it's really interesting to hear you say, no, even in a situation like that, where you think that this is something very positive, you have to be alert to the promises and commitments that were made in the context of the work permit.
Yeah. And if you're not, then you need to get a new work permit, depending on the circumstances. For example, if the duties of the job change, but then the national occupation classification remains the same, then it's fine. But if the duties of the job change and all of a sudden you're a manager as opposed to a regular engineer, you need a new work permit, and you can't get that particular promotion before you get the new work permit. So employers need to be aware of that.
Right, right.
Yeah.
So I want to talk a little bit more about inspections and audits and what those look like, kind of what employers can expect. And I think the advice that you've provided so far about making sure that you're regularly kind of reviewing your documentation, make sure you've got all your ducks in a row, make sure that you're aware of these compliance deadlines, keep records. But what can an employer expect if you've got an inspection occurring?
Yeah. So there's three types of inspections. There's a random inspection. There's a triggered inspection because the documentation appears to be anomalous. And there's a complaint inspection where foreign workers are complaining or they're applying for vulnerable worker work permits. And I could tell you a story of that, but I don't think we have enough time. I realize I'm looking at the time, so I won't. But it's interesting how a complaint can really create an issue for employers. If there's some deviation in terms of overtime or even sending the employer back at the time of ending employment, regardless of the cost or the cause. The inspections may be conducted during the period of 6 years from the beginning of the first day of employment, for which the work permit was issued to the foreign worker, for 6 years after the end of employment. So basically, once employment ends, you have to retain those documents for 6 years. And employers sometimes don't realize that. And you have to retain them just as you would, say, for the Income Tax Act or for employment purposes. And so once an audit is triggered, an investigation will occur. And what's interesting about these audits, these inspections, I use the term interchangeably, is that they're warrantless at office sites. If we're dealing with a situation where someone's a support worker or a caregiver and they're working in a home, then consent by the employer who is at home would be required, or otherwise you'd have to get a warrant. But if it's an office, inspectors can just walk in and they can do the inspection any way they want. They can videotape, they can go on someone's computer, no warrant required. They can interview any Canadian employees, any permanent residents, any foreign workers. They can interview the CEO. They can spend all the time they want, use the company photocopier, use the internet. They can do a very thorough investigation without a warrant. So I think it's a bit of a shock to employers that someone can just kind of walk in and take over their office. So
Right.
I think it's important that employers be aware of that. I mean, there's so much more I could talk about in terms of the inspection and audit process, but I think it's important for employers to know about the penalties for non-compliance as well. So,
absolutely. I was just going to say, I was like, I feel like we could talk for a long time about that. But but let's scare them even more by talking about penalties for non-com. No, I'm kidding. But no, I think that is really helpful to understand kind of what are we talking about? What are the potential liabilities here?
Yeah. So there's a bit of a tab. It's basically like a menu of non-compliance penalties, and it's based on a point system, and the more points you have, the more you have to pay. So it's based on type of violation, the employer's compliance history, the severity of non-compliance, the size of the employer's business for financial penalties, and whether the employer voluntarily disclosed information about the potential non-compliance before the inspection was initiated. And we do a lot of voluntary compliance documentation and requests so that to avoid future penalties for employers or to minimize them depending on the circumstances. I think it's a very useful tool, and employers should utilize that more often than they actually do, because 1 in 4 employers are audited. An inspection is triggered at least for 25% of employers. So, and employers found non-compliant as a result of an inspection could be subject to warnings or immigration program suspensions. The administrative monetary penalties based on this point system can range from $500 to $100,000 per violation, up to a maximum of $1 million over 1 year per employer. There's also bans of 1, 2, 5, and 10 years, or permanent bans for the most serious violations. Those usually relate to human rights, egregious situations. There's a website where various names of employers and their public websites, their names, their addresses, and the details of their violations and the consequences of their violations are listed. You can go on that website. It's actually very long, and it really does affect an employer's reputation. And then also, in addition to that, it could result in the revocation of previously issued labor market impact assessments. So there's also misrepresentation for aiding and abetting misrepresentation, where an employer is advising an employee to enter as a visitor or to become a contractor in order to avoid immigration issues. So those are considered as egregious, and jail times are up to 5 years or fines of $100,000.
Wow.
There's so much more I could talk to about this as well, but I realize we've run out of time.
Time has flown by as usual, and I feel like we could probably do a follow-up session at some point, because I have more questions that we didn't get to, but the information that's been provided is really helpful. And I think that, you know, in terms of consequences, listening to you describe these, I think what's really hitting home for me, and hopefully for our viewers as well, is that we're not just talking about monetary consequences here, because there's also that potential for that huge impact or interruption in business if you, for example, really rely on foreign workers, right? And you've got one of these bans or cancellation of previously issued permits. And then, as you mentioned, Jacqueline, the reputational impact of being on this shame list of employers who have not fulfilled their obligations. So there's much more to think about than just the potential monetary impact of something like a fine. And then, of course, you know, jail time on top of that as a potential outcome is definitely something significant that employers need to be aware of. So that's all really, really helpful. Thank you so much for sharing all of that. And I do hope we can have you back to talk more about kind of the impact of dismissals and terminations and resignations on work permits. And I think, you know, getting some general tips would be really helpful. So hopefully in a future episode, we can explore that with you.
That would be great. I would love that very much, Brittany. Thank you so much for having me.
No problem. Thank you so much. And that is a wrap on season 7, episode 5 of Fire Away. Thank you for everyone for tuning in. And thanks again to Jacqueline Bart for a great discussion. Thanks as always to Rob, Rebecca, and Mark for helping put the show together. Our next episode will be airing July 16th with Murray Miskin. Thanks for watching and have a great day, everybody.
At Rudner Law, we want people to treat their employment relationships as legal relationships and make informed decisions rather than assumptions. Keep up to date on Canadian employment law issues by following us on Twitter, Instagram, LinkedIn, and TikTok, liking our Facebook page, subscribing to our YouTube channel, and signing up for our newsletter. Past episodes can be found on YouTube, on our website, and archived on Facebook. And if you like our page or subscribe to our channel, you will receive notifications when the episodes are live. As we always say, none of that replaces legal advice tailored to your specific circumstances. If you think you might need an employment lawyer, you probably do. So please don't hesitate to reach out to us.